Introducing Lana Clark, Attorney at Law, Certified Specialist in Estate Planning, Trust, and Probate Law, California State Bar, Board of Legal Specialization.
Okay.
I don't know that.
I think it's kind of interesting to look at the topic of conservatorships, healthcare directives, and power of attorneys. Because what happens is if you don't have a power of attorney and a healthcare directive, what you're going to get is a conservatorship for you or a family member when you get to the point where you can't manage your own finances and medical decisions for yourself. So I want to make sure all of you understand what a conservatorship is and how it differs from a guardianship. Because I know I have a lot of people who come to me and they say, well, I need to get a guardianship for my dad. And so a guardianship only applies to minors. It's for children, people under the age of 18. If a person is over the age of 18 and they're an adult, and if they need someone to manage their finances or make medical decisions for them, and if they don't have these other documents in place that we're going to talk about, then you have to petition the court for a conservatorship. So that would apply in the event someone, even 18 or 20 years old, a young person, or an older person, somebody in their 60s, 70s, 80s, whatever age it is, if they're in a car accident and they have some injuries that make it so that they can't manage and make decisions for themselves, if you don't have documents that take care of that, you have to petition the court. Someone has to petition the court. It may be a family member, or it may be a friend, it may be a lifetime partner, whoever it is, someone who has an interest in helping that person. They petition the court. The court holds a hearing to appoint someone as the conservator, someone to manage their finances for them until they recover. So it's possible if somebody's in a car accident and you have brain injuries and you have to go to some type of a rehab facility, or if you have a stroke and you have to be in a rehab facility because you've got some paralysis, you may need a temporary conservator to manage things for you for a period of a few months or 6 months or a year. And you can get a temporary conservatorship, and you can also get a permanent conservatorship once it's determined that the need to take care of somebody else's affairs is going to be a permanent situation. Now, the negative thing about conservatorships is both they're expensive and time-consuming. The person who petitions the court petitions whether they want to be the petition of the person or the estate or both. And it's important to understand the difference between the two. If you're petitioning to be the conservator of the estate, then you're going to be managing just the person's finances. And sometimes you may have a situation where you have someone who has some medical disability or accident or situation where they really can take care of themselves, but they just can no longer manage the money. That's just a little bit too overwhelming, or it's just something they can't do. So the petition of the estate is the one who's managing somebody else's money for them. And if you're appointed as the conservator for someone else, that is an adult, of course, then you have to file annual accountings with the court to show everything you've done with their money. So there's a starting balance. It shows all the income that's come in, how you've spent the money, and the court looks at the bank, confirms the bank statement. They look at all the money that's been paid out, and the court will have to approve that accounting. Once a year, you have to petition the court, and the court may question some of what you're doing. So if anything looks inappropriate, then you've got a judge to oversee that. That provides some protection to the person so that the person acting as the conservator isn't spending their money or using it in an unwise or frivolous manner. So there is some great protection for the person who has a conservatorship. But the problem is the cost. To get a conservatorship started, just into the court system and getting someone appointed with court fees and attorney's fees to prepare all the documents, it probably runs about $5,000. That's a lot of money.
If you have power of attorney, doesn't that take place?
It does, and that's what we're going to talk about next.
Oh, I'm sorry.
This is if you have no documents. And a lot of times people at age 18 or 19 or 20, Maybe they have a sizable amount of money from an inheritance or from whatever source it comes in. And they think, well, I don't need the documents, or sometimes it just doesn't occur to them but every person over the age of 18 should have a power of attorney and a healthcare directive, so that they designate someone to make decisions for them if they can. And now, frequently people procrastinate. They don't do these documents until they even get closer to like age 50, and they think, okay, I'm now entering middle age, it's time for me to get these documents done. But young people need them as well. People that have their own families and their own children need documents to name who's going to be the guardian of their children if they have minor children. But a lot of times we kind of procrastinate those things and we don't do them because we always figure there's time tomorrow to get them done. And for most people, there is time to get them done. But for some people who have unfortunate diseases or accidents or illnesses, strokes, cancer, lots of things can happen. I mean, sometimes it catches you off guard. So if you're not prepared, you have to have a conservatorship, because the court's going to oversee what happens with that person's money to make sure it's being used properly for their benefit. Now, if you also go for a conservatorship of the estate of the person, then you're naming someone to make decisions about the person's personal lifestyle choices. Where do I live? You can. It also requires the conservator to give a consent before the person is able to marry or possibly vote, because sometimes you have elderly people who go in a nursing home and they meet their friendly guy Joe who's there and they want to marry, and you don't know if this other person who wants to marry someone is not really after their money. So sometimes there are reasons to put some limitations on giving an elderly person the right to marry. Now that's a fundamental constitutional right, the right to associate and marry, and so the court looks at those types of restrictions in a very serious manner. But if someone has Alzheimer's or dementia and they're just giving their money right and left, giving it away because they're not understanding what they're doing, a conservatorship is important. Now, everyone has the right to decide where they live, even if they have some medical conditions. So the right to decide where you're going to live, if you're going to go in a nursing home or if you're going to be cared for at home with caregivers, that's the person's choice unless that right has been taken away. And the only way that right can be taken away is with a conservatorship. So for some people, a conservatorship is a very important but serious process. So it's a real gift when you agree to act as a conservator for another person, because it takes your time and effort to make sure that the other person is being well cared for. It doesn't mean you have to actually be the caregiver, but if you're the conservator of another person, you have to be in charge of making sure they have caregivers if they need it, placing them in some type of a home setting where they can have the care that they need. So the whole concept of a conservatorship is really designed to help protect the person's personal rights and their money. So because that's an expensive process, although it's sometimes very necessary, it's there to help people when the need arises. But if you have some planning done ahead of time, there are ways that those things can be accomplished without involving the courts. And the way that's avoided is with a power of attorney for financial management and a healthcare directive. Now, one of the things that I've given you is a sample of a healthcare directive, and that's a form that can be filled out. It needs to be notarized or witnessed by two people to be effective. And it can't be witnessed by the person you're naming as the agent. Two outside people, not a family member that you're naming. That way it helps to make sure it's valid. Now, the person who's signing this gives the permission to someone else to make medical decisions for them. And probably the most serious decision you're giving someone with a healthcare directive is the decision to terminate life support. So if you're in a coma, you're not expected to live, you're being kept alive by machines, this document allows you to designate the person who will have the ability to tell them to terminate life support. So this is a very serious document, but without it, the doctors and the hospitals will keep you hooked up to the machines to keep you alive, because that's what their committed to doing, is helping people stay alive. But when all hope is gone, and you know that even if a person came out of a coma, they would be in a vegetative state, most people kind of would say it's time to let me go. So this is the document that will allow you or any person over the age of 18 to be able to designate someone to make medical decisions for them. And certainly when a person develops dementia or Alzheimer's or something else that affects their mental ability to make these decisions, when they've lost capacity, then this agent can step in and deal with doctors and hospitals to give consents for medical treatment or surgeries if necessary, whatever. So this healthcare directive is very, very important to have, because none of us ever know when we're going to be in a gnarly car accident and have some real issues to deal with medically. Yes?
Does a power of attorney just mean medical decisions, or can the power of attorney be financial?
There are two separate documents. One is a healthcare directive names someone to be your agent, like a power of attorney, for medical decisions only. Then there's a separate document that's a power of attorney for financial decisions. Everybody should have both. A power of attorney for medical and a power of attorney. In California, we call them healthcare directives, but you're naming an agent to act for you. So, two documents.
What's the other one called? You said one's called medical and one's called...
One's called Advanced Healthcare Directive, just like this one is one of them. Advanced Healthcare Directive.
Okay, yeah.
And then the other one is a power of attorney for financial management. Two separate documents. Now, there's a third document that California now has, and it's called a HIPAA authorization, and that's a third document that's really important to have. And generally that goes in correlation with the healthcare directive, because doctors and hospitals will not release information about your medical condition to other people without you signing a consent to release that information. This came up in 2005, if my memory on the year is correct, when hospitals and doctors felt that it was important because they were being sued by a lot of people for revealing personal information. Certainly if someone's revealing information about your psychiatric or condition or sexually transmitted diseases or other personal confidential information, people would sue the hospital for releasing that. And they might have told family members even. So now hospitals will not release or tell any information other than very minimal that the person is stable, but they won't give detailed information about your medical condition, even to close family members, without you signing this. So when you go into the hospital to have a procedure done, or for some sort of surgery, if you don't have a HIPAA authorization and a healthcare directive, they will ask you to sign one, and that applies for the time you're in the hospital. But when you get out, that HIPAA authorization doesn't apply anyplace else. It's only for that one hospitalization. So once you have this healthcare directive and a HIPAA authorization, I tell people to take it down to the hospital where they normally deal with. You've got Marion up here. Down in my area in Santa Barbara, we've got Cottage Hospital. And so you take it over to the hospital and they will scan it into their computer systems and it's permanently there. Now you don't have to worry. They've got your records. They know who you have consented to have this information communicated with family members or close friends. And they know who your agents are. And it just stays on their records permanently. So if you have to be rushed to the hospital, they already have access in their computers to who your agents are. If you're traveling on a vacation and you're on a driving trip or flying someplace, I always recommend that people take one of these, put it with them. Take it with them in an envelope, stick it in your suitcase, put it in the glove box of your car so you have that with you. So if you're in Kansas and you're in a car accident, you've got that you can present to whatever hospital you're going to. So that's a recommendation, that you put a copy of this document in your glove box, and I always stick one in my suitcase if I'm traveling. It's just important to have that document with you. Now, there are different types of healthcare directives. Probably the most common one that you may hear of is one put out by the California Medical Association. It's kind of a form that you fill in the blanks, and it says who do you want as your agent, what type of treatment do you want to decline, and so you check the boxes, fill it in, and sign it. Doctors and hospitals are familiar with that form because they see it a lot, so there's the advantage of having that form when the doctors already know about that form. There's also a form that Cottage Hospital gives out, and it's one called 5 Wishes, and it's very unique. A lot of people like it, other people do not like it, so that's a different form. And in the handout that I have, there's actually the website listed where it's on page 4, where you can go look at it, and you can actually purchase it for only a cost of $5, kind of toward the bottom of page 4 of the handout, just above the conclusion. And this 5 Wishes form kind of has a lot of questions where you can designate how you want your body to be treated if you are in a coma. You finding it? It's one that's, yeah, page 4 of this one. Okay, so
Aging with Dignity.
yes, Aging with Dignity is the company that puts it out. You can look at it on their website. Now, the thing that makes the 5 Wishes Healthcare Directive a little different is it tells even more than just who's the agent that's going to make decisions for you. It has a place where you can check the things that you like. If I'm in a coma, I want my body rubbed with oil. I want soft music played in the room where I am. And if you're in a coma, all of these things may be something you would like to have. Some people say, well, if I'm in a coma, I don't care. Yeah. Who knows? But some people believe that there's still maybe a subconscious that may have some sense of understanding even while you're in a coma. If those things are important to you about music and how your body is treated, you may really like the 5 Wishes. So it's something to look at and compare. And of course it also says that I give permission to terminate life support if that's needed. So that's a form that you have as an option to sign. There's also a customized form that I do as an attorney that's much more, it's kind of much more detailed, and it provides not only decisions about medical, but it designates whether you want to be an organ donor, and if you want burial instructions, certain types of things that you want done. So it's a little bit more comprehensive. It's a little longer document, but it's something that can be customized to your desires. So there's 3 different types of healthcare directives. You have to decide what's the one that you feel most comfortable with. A fill in the box, a more comprehensive one about how I want my body to be treated while I'm unable to do that, make those decisions for myself, or a comprehensive one that may be more suited to what you want to do. So those are things you can talk with an attorney about. You can make the decisions on your own, but the important thing is for it to be valid, it has to be properly signed. And that means notarized or signed by 2 people as a witness. And if a person who's signing a healthcare directive is in a nursing home, it also has to be signed by the ombudsman who's in that nursing home facility to make sure that somebody is not exerting undue influence over them to get them to agree to sign documents.
That was what I was going to ask. Is all of these documents have to be notarized? And,
yes, either notarized or witnessed by 2 people.
Yeah.
And if the person's in a nursing home,
So
it has to be witnessed by 2 people and an ombudsman.
Yeah. Okay.
Every nursing home has someone designated to be the ombudsman to make sure that somebody isn't slipping in and convincing people to sign documents without them really understanding it. So that's important. Okay, so now let's talk for a minute about power of attorney documents. And you can feel free to continue to ask questions as we go along. So in the very first page of this handout, it kind of has an interesting scenario that kind of says, you receive a phone call from a doctor or hospital official saying your mother's been hospitalized after a fall, and the initial evaluation is that she needs a hip replacement surgery. You're the nearest child who's been helping with care for your mother, and her mental abilities have just deteriorated. So, you know, what are your options to solve the dilemma? So we've talked about conservatorships. We've talked about healthcare directives to prevent a conservatorship. So now the next step is to say, what can I do to avoid a conservatorship, to name somebody to manage my finances for me in case I am temporarily or permanently disabled or incapacitated where I can't manage my own finances. So that document is a power of attorney document, which is explained starting on page 2 and 3 of the handout that I've given you. So now a power of attorney has different types of power of attorneys. And so if you're going out of town on an extended vacation, but you have this escrow that is already in the works, and you're not going to be around to sign the closing documents, you can have a special power of attorney that's limited only for the purpose of designating someone who has the ability to sign documents for you. And it terminates at a certain time after the escrow closes, and those are very effective short-term, limited-use special power of attorneys. Those people don't do those very often because those types of situations don't come up except occasionally, but nonetheless, that is one type of power of attorney. The most common types of power of attorney is a durable power of attorney, and this one you fill it out now to designate the person you want to manage your finances, and usually it's your partner or your spouse, and then you name someone as an alternate and maybe even a second alternate in case the first person isn't able to do it, or if you're in a common car accident with your husband and your child that are both your agents, now who's going to do it? You have to have another alternate. So it's really good to have the first person you name and at least one alternate, but maybe two, just in case you're all together in some family outing and some really catastrophic accident occurs, which is kind of the reason why a lot of people who have great amounts of wealth that they have concern about, they never all fly on the same plane. Because if your whole family is going to a place for a family reunion and the plane goes down, now everybody is out of the picture. So they fly on different planes, and it's just an extra precaution, and it doesn't happen very often, but when it does happen, it's pretty devastating for a family to have a whole family that's wiped out in one time. Okay, so the durable power of attorney is a document that is still effective once you become incapacitated. So if you develop Alzheimer's or dementia, this power of attorney is durable. It doesn't stop. It's lasting for the remainder of your lifetime. Many years ago, decades ago, power of attorneys used to have a limit where they would only be good for 7 years. Now they're good for the rest of your lifetime. You can change them if you want to change your agent, but you have to take some steps to make sure you void the old one. And if that power of attorney has been given to any banks or investment advisors, you have to let them know that you're canceling it, and let them know who the next agent is. Because once a person has been named as your agent under a power of attorney, that person, when they get a doctor that certifies that you're incapacitated, can take that power of attorney to the bank, be added to your checking account, and can start writing checks, liquidating your assets, and basically spending your money. Now, they're restricted where they can only use it for your benefit, but I've seen instances where a son will get the power and go dip into mom's account, and next thing you know, $10,000 has been taken out. So what's mom going to do? Technically, she can sue her son to have him return the money, but a lot of times parents go, oh, well, that's just Johnny. He needed the money, and so, the money goes off. But there can be some criminal issues, elder abuse issues. If the person you're naming goes beyond their authority to manage your money, and if they even invest your money in very frivolous or high-risk investments, and they cause a lot of money to be lost, they can be personally liable. But collecting it involves filing a lawsuit against them, and that's lengthy and expensive. So a lot of people just kind of shrug it off and say, oh, well, my agent has taken more money than what they should, but they just kind of blow it away. Sometimes when it's many tens of thousands or hundreds of thousands of dollars, then it becomes a more serious issue. The district attorney's office will look into elder abuse charges and decide whether they're going to file criminal charges or you file civil lawsuits to get them to return the money. All of those things are expensive. So how do you avoid that? You have to be real careful in the person you choose to manage your finances for you. Can you trust your own children or your friend or relatives? That's a personal question that only you can answer. Certainly if you have children that are involved in illegal activities or drug abuse, they would not be good choices to manage your finances for you, because the money might be more likely to be taken away and used for improper purposes. So now your power of attorney you can state that it's effective immediately. And this is appropriate for elderly people who want to bring in a child to say, I want my daughter to start acting immediately as my agent. So that power of attorney can state that I give this power immediately to my daughter or my son or whomever you're naming. And that person can then start signing on checks or managing financial investments for you if you feel, you're ready for that person to do it right away. Most power of attorneys have a springing condition, so it doesn't take effect until a doctor signs some sort of a certification that you're incapacitated. That's kind of a protection to you because it prevents somebody from stepping in and doing it sooner than what you want them to do. So as long as you're able to manage your finances, you can keep doing it. But once you get into that position where you're not able to do it on your own, then the doctor can certify that and you then have someone step in and help. So whether it requires one doctor or two doctors is different in different types of power of attorney forms. You can get forms for them. You go online and do searches. You can find a lot of forms. Whether they're appropriate for California is the question. Whether they're appropriate for your circumstance is questionable. So doing a lot of self-help, it may be fine, it may not. And unfortunately, you don't know if your document has got defects or is faulty or isn't follow California law until you get to the point where you need to use it. And then if you find out if it's defective in some way, then you've got more problems to deal with. So generally you go to an attorney when you're having an estate plan done. You have a will done, power of attorney, a health care directive. If you have more than $150,000 worth of combined assets, then you're going to have a probate at the time you pass away. So in order to avoid the probate, you can create a living trust. And certainly if you have a house, you want to have a living trust to designate where it's going to go. You can own a house or a bank account jointly with someone else in joint tenancy. When you pass away, it goes to the other person. But then when that other person passes, that house has to go through probate unless you have created a trust, changed the title to the house into the trust. So there's some things about having a trust that avoids probate, which is kind of a different subject than power of attorneys and healthcare directives. But frequently when you go to an attorney to have an estate plan done, you're having all these documents done at once. You kind of say, let's get everything in order. So you have a trust, a will, power of attorney, healthcare directive, a final disposition document to say whether you want to be cremated or buried, and if you've purchased policies for that to be done, changing title to your property into the trust. So all of those are done all at one time when you're having an estate plan done. So let's see if I have... Okay, I think I've pretty much covered everything that's in the handout. There's a little bit more detail in here, and I encourage you to read it to help you remember the things that I've told you and to, kind of solidify your knowledge. So now once you have the knowledge, then you have to... There's my notes of the things I'm going to talk about. See if I've forgotten anything. I think I've covered it all. After you've done this for 20 years like I have, it just kind of flows. You don't have to refer to a cheat sheet to know what you need to cover. There's another handout that I did give you, which is kind of an interesting and important one. It's called California End of Life Option Act. This is kind of a new event because it only took place on June 9th, 2016. It became a law. Governor Brown signed this last fall, and this gives people who are at an end stage of life, who are ready to terminate their life, that they can do that. It's kind of like Oregon's assisted suicide thing, but there's some restrictions about who can qualify to do this, and it's not having a doctor terminate life support for you, which is like Dr. Kevorkian was helping people do. This means that if someone is terminal, they're in a lot of pain, and they have the ability to really understand and make that decision for themselves, that a doctor can give you the medication where you can self-prescribe medication to bring an end to your life. It's kind of a scary and serious thing to ponder for anyone, but I've known people who have seen a parent go through excruciating pain for the final few weeks of their life, and sometimes it is appropriate. So because this is such a new law and a new thing that California is looking at, I printed this out from the California Hospital Association, and something, just more knowledge for you to have. I do know that Cottage Hospital has decided they are not going to participate in this type of assistance for people. It is optional whether a hospital or a doctor want to do this. It's not a requirement. And I'm on the board of directors for the Cottage Hospital Foundation for the hospital in San Ynez Valley. So I hear a lot of things and become aware of things about what's going on in hospitals, and I like having that knowledge. What you do with it is up to you. It's just kind of interesting to note that now California now has that option for people who are at that stage of their life.
Yeah.
Does that require an attorney's involvement?
No, it doesn't.
Okay.
It doesn't. All the requirements are on here.
Interesting.
Yeah. I think you have to have doctors, and you have to, meet. You have to have 2 oral requests that are at least 15 days apart. So the person has to make the request to their doctor. 15 days later, ask again. So it's not for someone who wants to make a quick decision. It has to be very thoughtful. Do you have another comment or question?
No.
We got it?
I got it.
I do. Regarding the advanced healthcare directives, you mentioned the HIPAA authorization. Is that included in the directive, or is that a separate document?
It is a separate document, okay. Although all of the healthcare directives and power of attorney forms, I have a HIPAA provision included in them.
Oh, very good.
But that provision in the document only says that, it basically says that I want the person that I've named in a power of attorney and in the HIPAA authorization as my agent to be able to find out information about my medical condition. The actual HIPAA authorization can include more names. Mm-hmm. So those 2 is just for the agents, but I know a lot of people say, well, I've named my spouse and 1 child as the agent, but I do want to make sure that they communicate all the information to all my children. If they show up at the hospital after an accident, it's kind of a real touchy situation if the hospital will only talk to your agent and the rest of your kids, you have to go outside. So the HIPAA authorization allows you to name all of your children or friends or family members that it's okay. So everybody can stay in the room and talk with the doctor and find out information about your medical condition. I would hate for any of my children to be excluded when other children were there.
And that would be a separate form
based
on a specific event or something that...
So it's a separate form. So you really need 3 documents.
Okay.
A power of attorney for financial management, a healthcare directive, and a HIPAA authorization.
Okay.
Those 3 will keep you from having to have a conservatorship. They don't have anything to do with avoiding probate. That has to do with the way you've titled your documents or you have a trust. So that's a whole other situation.
Okay, and going back to the conservatorships, the different types of conservatorships, the ones that are financial, are those forever, or are they renewed, or how do they?
They're renewed. They're renewed. The courts will look at them every 2 years and decide whether they can go on. The court sends out an investigator to interview the person who's going to have their assets managed. So they monitor it, and it can go on for the rest of a person's life. Certainly if someone has Alzheimer's and they're not going to get better, it's going to continue the rest of their life. But every 2 years, they do a review, they send the investigator out, they come back, you have to give a report to the court and fill out the details about what's happening in their life. And if you are also managing finances as well as making decisions about their personal care, then you have to provide the accounting. You can hire an accountant to do it, but it's got a balance to the penny, and it's got to contain everything that's important that the judge wants to see. So yes, they can go permanently. But if a person dies, then the conservatorship needs to be terminated. If a person gets well, like if it was a temporary situation where they had some accident, injuries, and you get well, then you petition the court to terminate the conservatorship, and the person then takes back over control of their finances. But every time you petition the court, there's a fee of $435 plus other filing fees to get it electronically to the court, and then there's the cost for the attorney to prepare the petition that goes to the court. So every petition you file with the court is going to be at least $2,000 for filing fees and the attorney's time. Maybe more, depending on the complexity. But
do they also charge for the accounting?
The court does not charge, but
Okay.
if you have to hire a CPA to prepare it, then you're going to be paying a CPA to prepare an accounting. Or you can do it yourself if you have the ability to make everything balance, which is sometimes pretty challenging. Struggling just to balance your own checkbook is a difficult task for a lot of people. Yes, ma'am.